Okay, what is the 90-day rule, and is the 90-day rule dead? The 90-day rule is in the Foreign Affairs Manual, which is rules that are followed by the U.S. consulates around the world when making a determination whether to allow an immigrant to immigrate to the United States. There's a rule in the Foreign Affairs Manual that essentially says that the consulates can presume you committed fraud if you take certain actions within 90 days of entry to the United States. That means you don't have to be caught red-handed, but if you take certain actions, they can presume you were committing fraud or misrepresenting facts to them. The 90-day rule replaced the old 30-60-day rule under the Trump administration. Also under the Trump administration, in 2018, USCIS incorporated the rule by reference. They incorporated it as a persuasive tool to use for the adjudicators when determining cases inside the United States. However, in the summer of 2021, USCIS removed all mention of the 90-day rule from the adjudicator's practice manual. Therefore, there is no longer a mention of the 90-day rule in the USCIS adjudicator's practice manual. So, how does USCIS determine whether someone has committed fraud or misrepresentation if they're not using the 90-day rule? And do they presume fraud or misrepresentation in the absence of concrete evidence or express fraud? USCIS will use the reasonable person standard and look at all of the activities done after arrival in the United States. If they do not catch you in express fraud, they may presume that you committed a misrepresentation or a fraud, and because the burden is on you to prove your case, they will essentially burden shift and force you to prove that you did not commit fraud or misrepresentation. So what are some examples of extreme cases where USCIS may seek to deny a case for actions taken within a short amount of time after arrival in the United States? Well, let's take an example first of someone who recently applied for a tourist visa. They applied for it just prior to entering the United States, and they only made one entry to the United States. When they were at their interview applying for the visa, let's say that they told the officer that they intended to go visit their sister in Florida and go to Disneyland. Further, let's say that they were engaged to a U.S. citizen but did not mention this. Once the visa was issued, they bypassed Florida, did not visit Disneyland, did not visit their sister, flew straight to Colorado, married that U.S. citizen within a very short amount of time of being in the United States, and applied for adjustment of status. Under that scenario, because the notes and information from the visa interview will be available to USCIS, and because the immigrant did not follow through with what they said they were going to do, they married within a very short amount of time of arrival in the United States, and it was the first time they used the visa, USCIS may, in that case, seek to deny the case for discretion based on preconceived intent. In that particular example, it would be not as bad if the immigrant used the visa maybe multiple times. So in this scenario, the immigrant did not visit their sister in Florida and did not go to Disneyland, but exited the United States and re-entered the United States multiple times before eventually staying and marrying the U.S. citizen. Further, in this scenario, let's assume that they were in the United States for a full 90 days or so before marrying the U.S. citizen. That is a much less egregious case, and USCIS would be much less likely to take any action in that scenario. So, if you have taken action within a short amount of time after arrival in the United States, and that action is inconsistent with your visa type, will your case be denied? It depends. USCIS, if they catch you in a lie, can force you to get a waiver. For example, if they ask you what you told the officer at the Customs and Border Protection officer at the airport when you arrived in the United States, and you said that you were going to visit a girlfriend, and they looked on your Facebook page and it turns out you had already been engaged several months prior, they will consider the use of the word girlfriend and not fiancé as a misrepresentation and potentially require you to get a waiver. If they do not catch you in an actual misrepresentation and they attempt to require you to get a waiver, then that would be an easy appeal to win. If they did not catch you in an actual misrepresentation, what they can do is seek to deny your case based on discretion. However, if you are married to a U.S. citizen and the only thing USCIS has against you is preconceived intent to immigrate to the United States, most likely they will not deny your case. There is case law from the Board of Immigration Appeals. There's a case from 1980 called Matter of Cavazos. And in that case, the Board of Immigration Appeals basically said, if the only thing you have against the person is preconceived intent, and that person is an immediate relative, which includes a spouse of a U.S. citizen, and there are equities weighing in favor of adjustment of status, you should go ahead and let the immigrant adjust status. And that makes sense because before 1960, there was actually a statutory law that prevented you from adjusting status if you had preconceived intent to immigrate to the United States when you arrived. Since Congress removed the old law in 1960, it seems to indicate that they no longer wanted that to be a basis to deny the case. However, the Board of Immigration Appeals has also made clear in another case, Matter of Ibrahim, that this benefit only extends to immediate relatives of U.S. citizens. For example, a spouse of a U.S. citizen. Therefore, if you are a spouse of a permanent resident and you had preconceived intent, and USCIS determined that, they would be much less likely to give you the benefit of the doubt and much more likely to deny your case. So what if you were outside of the United States and thinking about visiting the United States and curious about the adjustment of status process here? What should you do? Well, I recommend that you do not have any preconceived intent to stay. You should really have open plans, and that should not be your intent from the beginning. You should not have a big wedding planned. You should have a return ticket. You should not lie to immigration officials in any way. You should just live life. Don't be so uptight. Don't be so determined to stay. Perhaps the significant other in your life who you intend to marry is not the right person for you. Perhaps spending some time in the United States, you'll realize that the United States is not the right location for you. So I always tell people to keep open plans when coming to the United States. Do not have preconceived intent to stay. And then if it turns out later that you ultimately get married and decide to stay, then great. But that way you're not in violation of any rules and it doesn't look bad. You're less likely to get caught in some kind of dishonesty, whether it's dishonesty that's intentional or even dishonesty that's perhaps unintentional. So is the 90-day rule dead as far as adjustment of status and USCIS is concerned? Well, yes and no. It's not a rule, it never was. It was all a lot of hype, really. USCIS will use the totality of circumstances, the reasonable person standard, as they always have. They never gave much weight to the 90-day rule as it's in the Foreign Affairs Manual. However, I do think it is a good gauge of your own activity and worth thinking about when you're making decisions about what to do next. For example, if you are already in the United States and you're in love and you really want to get married and stay here and file for adjustment of status, but you've only been here 1 week, maybe you should think to yourself, hey, am I jumping the gun here? Is this a little too early? What are other people going to think about this? Is 1 week reasonable? Okay, that's not to say that 90 days is always going to be reasonable, although it most likely is. That's a long time after being in the United States to take any action. I think the 90-day rule is a good thing to keep in mind as far as a gauge of whether your activity may seem unreasonable to someone else. However, it is not an actual rule, and if you did perhaps get married quickly after arrival in the United States because you were in love and weren't really thinking through the consequences, I don't think that's the end of the world. You shouldn't get pessimistic or negative about it. It's probably fine. You're more than welcome to contact me for a free consultation. Visit my website at denverimmigrationlawyer.com, and I'd be happy to talk to you about your particular situation. But if you have not taken action that could be inferred as preconceived intent by USCIS, consider your next steps wisely. Thank you and have a nice day.